Welcome to this free immigration help channel. Today is April 5th, 2023, and we are getting into the volume 53 of me answering all your immigration related questions in the comments. As you can see, I have all of them pulled up here. Before I begin though, I'm going to mention I am not an immigration attorney. This is not a legal advice. All the information that I provide in these videos on this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first comment from Joel Flores. Hello, I didn't want to comment so I don't feel dumb, but I have a TN visa. It expired in July. I'm trying to extend my stay without going out of the country. I did watch the video where you help your friend. I'm really trying. Do I have to get the I-539 too, or I just need the I-129? And if I do have to get the I-539 on paper to send it with the I-129, or I can do it online and then send the I-129. Joel, the very first thing that I'm going to, well, first things I'm going to say thank you for your question. The second, I'm going to say, please don't feel down, and for everyone who's watching, you know, everybody's been there, you know, whenever it comes to the immigration process, dealing with an immigration, whether you have an immigrant petition or a non-immigrant, whatever it is, whatever the situation is, it's a new area for pretty much anyone who did not deal with it unless you work in that area. So don't feel dumb at all. There is no dumb questions whenever it comes to immigration. It's better to be safe and double check and ask questions than assume something and then make a mistake. Okay, now whenever it comes to the question now, Joel, so TN visa, if I'm correct, that's NAFTA workers for Canadian workers, if I'm correct. But let's take a look at because the very first thing I'm going to say is, of course, the extension of stay, but I'm going to use this as an opportunity to demonstrate the navigation on official U.S. Citizenship and Immigration Services website. We're going to go to forms here at the top navigation menu and then all forms, and then I'm going to find the change of non-immigrant status extension of stay, which is 539, which is one of the things that you're referring to, because I'm pretty sure that you cannot file the form I-539 for the extension of TN visa, and I want to double check myself if I'm correct on that. And here we're going to scroll down and we have you must not file form I-539 to request an extension of stay for these things right here, and there you go, TN. Okay, so yes, you cannot file the I-539 for the TN, and it makes sense because TN is considered an NAFTA worker, basically a work visa. So with that being said, if that's the case, then the only thing that you need to worry about is that form I-129 that you're referring to. However, technically it's not you who needs to worry about the form I-129, it is your employer, because it is the employer that files the form I-129 on behalf of the employee, basically not necessarily petitioning, but applying for additional time, saying that, hey, you know, this employee that we have, he is still employed with us, he's still working, here's another form because we want additional. And I'm pretty sure the TN visa is issued for 3 years, and after 3 years, if it's expiring, and if basically the employment contract continues, the employer submits that form I-129 to get more time, basically the extension for that visa. So we're gonna go to forms, all forms 129, and this is the form. You can literally just send the link, and as you can see, you will find, let's see, is there a TN? Do they mention TN here at all? Help you do. No, it doesn't mention the TN here, but you can forward this link. Let's see. No, the T. Oh yeah, there you go. Let's see. Petitioners may also use this form to request an extension of stay in or change of status to E1, E2, E3, H1B1, or TN. There you go. Found the thing that I was looking for. You can forward this link right here, and in fact, I'm gonna copy this. You know what? Actually, I'm gonna do this, and I'm gonna let you know that not in 52, in 53. And also I will copy this link right here and I'll type link so that you can forward this link to your employer, and because it's them that has to fill it out and then send it. Obviously you can assist them along the way, and it's really great. So again, nothing dumb at all about this. It's great that you are doing the research, that you are familiarizing with the process, so that when your employer is filling the form out and filing it, obviously most likely your employer is not familiar with anything that has to do with USCIS either, so you can answer the questions for them as well and be helpful. All right, let's move on to the next question. Comment from Jefferson Argandona Messias, and I'm very sorry if I'm mispronouncing the name. Visa type IR5, priority date 30 April 2021, document complete August 2022, interview location Ciudad Juarez, Mexico. In how long should I expect an interview date? Thank you. Jefferson, you're very welcome. Thank you for asking the question. So IR5, it's the priority, sorry, it's too early for me. It's for the parents, okay? For the parents of US citizens, all right? This is the category. So, with that being said, there is no visa cap on this priority category, which is great. Immediate relative of a US citizen, no visa cap. So you don't have to deal with the visa bulletin and look at this wait, how much backlog there is, none of that, which is great. And if you're a parent, I don't know if you're a beneficiary or if you're the petitioner, but the beneficiary was already documentarily qualified in August 2022, which is, let's see, November, December, January, February, March, April. Okay, so we have 8 months. 8 months, I'm gonna, because I want to give you a pretty good answer and tell you exactly how long these things take after the approval. Okay, so here we go. Let's see. All right. So this was December, and then we got this in August. Okay, so August, December, January, 8 months. Okay, so 8 months. So looks like that's how long these cases are taking, about 8 months. Now, I wouldn't be surprised if it takes maybe a little bit longer because it is in Mexico. And the thing is with Mexico, because the immigration numbers in general are a little bit heavier from Mexico. Well, I say a little bit, quite heavier from Mexico compared to a lot of other places. That's why Mexico has their own separate chargeability area. If you look at that, and it's only 4 countries: it's China, India, Mexico, and Philippines that have their own separate chargeability areas. It only applies to the visa bulletin. However, I would not be surprised if there is, extra few months. So you're at 8 months. That's how long they typically take to schedule the interview. I would say you are anywhere right around the corner. Your interview should be scheduled. Congratulations being undocumentarily qualified. Hopefully it doesn't take any longer. But if you can provide an update once the interview is scheduled on this channel, just like that, separate comment, I'd really appreciate it. It's always good to see. I'm very happy to receive the questions because it tells me that my answers are helpful. But I'm also very happy to just read the comments of the resolution saying, yes, interview was scheduled, yes, I got granted, or I successfully submitted the application or something. It's good to know that the action is taken and everything works out. Okay, let's move on to the next comment from Avia Wu. Avia, thank you very much for being publicly subscribed. I appreciate this. Hi, this is from Hong Kong. When will be the F4 move? Okay, so the F4 is a forced priority category and it's for brothers and sisters, for siblings of US citizens. And unfortunately, it's the category that takes the longest. And currently, if you check on the visa bulletin as of April 2023, this is the most recent visa bulletin. It just came out like a week ago. And if you look at the priority dates, you will see that there's about 16 years of backlog on these visas. Now, this is as of April 2023. I think it will update in the next couple of months, and we will have a little bit of a better idea, because these dates did not change for now probably like a year and a half. All right. So we might see an additional time added in the next few months to this existing backlog, basically, but very roughly is 16 years, unfortunately. And I wish I could give you a better answer, less of the time, and I can personally relate to the F4 category, because I myself have a petition, the I-130 petition for alien relative in F4 category, and I have a me and my brother, we have a very, very long time to wait until the immigrant visa becomes available. It's unfair. I don't think that's right, but that's the way the system is for now. We'll see. Hopefully there's something can be done, and maybe we will see a positive change, but it's hard to tell. All right, let's move on to the next comment from Wacko Wacko. I'm a little surprised about your point on tax transcripts. They expressly say you only bring original copy of the civil documents and not any financial documents. This is on the website that they send you, and they are not asking for that. This does not make any sense. They have already been submitted and approved at NVC. Why they asking for things already reviewed? Well, Wacko Wacko, I really don't know what to tell you. It's not me creating these rules. It's the USCIS, NVC, US Embassy, whoever's dealing with your case at the moment. But whenever it comes to the interview, they do expressly, specifically tell you, when they send you an email with the schedule of the interview, they expressly tell you that you do need to bring tax transcripts, not tax returns, not anything else, not just the civil documents, but tax transcripts. All right. In fact, I would still recommend bringing tax returns just in case. But they actually did have some denials. I've personally seen a denial on the interview because the person actually brought the tax returns, but didn't bring the tax transcripts, which apparently is two completely different things. And honestly, it's silly. It's really silly, because to me it's just a bureaucracy. But this is I would say pretty new requirement, because before they were just okay with the tax transcripts. Now they specifically request the tax. They were okay with tax returns. Now they specifically request the tax transcripts. I would say as of probably like a year, maybe a year and a half, and that's for the interview. Now I kind of understand why they do that. It makes sense because, they are interviewing, a prospective immigrant, a prospective resident of the United States of America, right? So they want to see some kind of understanding of the way the system works, of the way the financial aspect of it works. And, filing tax returns, having all of that information is obviously shows that you kind of understand the way the IRS and all that sort of stuff. Because once you immigrate to the United States and you come here, you'll have to deal with it. So if you're not willing to familiarize yourself with the process of filing taxes and all that sort of stuff from the petitioner side, obviously, because beneficiary they don't deal with that yet. Again, it kind of shows the intention, whether you really are planning to immigrate to the United States and live in the United States and prosper in the United States. So I'm gonna put this, but yes, whatever website. I mean, you can do the research. It's good to do the research, especially if you're getting your information directly from Department of State or from USCIS. But the final thing is going to be the notice for the interview, and that's where you will see the requirements for what you need to bring. All right, let's move on to the next one from George Galindo. I traveled to the USA with an immigrant visa. My citizen mother asked me, and I had an interview and visa in my country. Okay, I traveled to the USA with an immigrant visa. My citizen mother asked me, and I had an interview and visa in my country. Okay, great. So your mother filed the I-130 petition and you got, okay, perfect. What should I put in part 3-1, embassy of my country or an office in the USA? Ah, I see. So you're asking about the renewal of the green card. Okay, so let's take a look. I'm gonna use this again as an opportunity to navigate on USCIS website. We're gonna go to forms, all forms, find 90. Now these are in alphabetical order, so you can just scroll down and find the form, but it's much easier obviously to type it up. We're gonna open up, let's see, forms. We're gonna open the form itself. And let's see, 3-1, part 3. I'm assuming that's part 3. -1. Okay, processing information. Location where you applied for an immigrant visa or adjustment of status. Location where your immigrant visa was issued or USCIS office where you were granted. Okay, okay, perfect. I see. So let's see, 3-1. Okay. Location where you apply for an immigrant visa or the adjustment of status. Okay, that would be the U.S. Embassy in your home country where you got your immigrant visa. So that's it. That's really it. And also, usually this stuff, I mean, it's definitely important, but for the most part, it's not that huge of a deal because you really are applying for the renewal of the green card. Another thing that I wanted to ask, if you're applying for a renewal of a green card, why not apply for naturalization? Just a suggestion, just an idea. N400, if you're interested to check it out, application for naturalization, but just throwing it out there. All right, I'm gonna pause this and we're gonna move on to the next one from Simone Williams. Thank you very much for your answer, Simone. You're very welcome. Okay, that's what I'll do. Keep logging into the CAC so I'll know when any message is sent. Appreciate every moment of your information. Thank you, Simone, again. And even when I have no questions, I still continue listening to you, and I'll surely keep you informed anytime any changes make in my case. Have a great day. Simone, thank you very much for your kind words. I really, really appreciate it. Like I said, you know, I'm very, very helpful, grateful, not helpful. I mean, it's for you to determine whether I'm helpful or not, but I'm grateful for your questions. But I'm also grateful to, you know, just get the message and say that some kind of resolution message. It's really good to know. But let's move on to the next one from Sassy Diva. Thank you, Sassy Diva. Thank you for your question, and I'm glad my answer was helpful. Moving further to Annette Mascarenas. And Annette, actually, I have your email pulled up in front of me here as well. I'm gonna read it too. Let's see where it is. There you go. Okay, so let's read your comment first. Is the employee able to work prior to receiving the visa, or can they just show proof of the visa being filed to legally work in the US? And then I'm gonna read your email. Hello, I'm trying to find out some more information regarding work visas and can't seem to find it anywhere. I am wanting to know if you show proof you have filed for the 765. Does that allow you to legally work? Thank you for your time. Your videos have been very informative. Annette, thank you for your kind words. Okay, so whenever it comes to employment authorization document in general, the nature of it is a little bit different compared to some other applications and petitions out there. Meaning that whenever it comes to a lot of other petitions, once you submit the applications, once your application is accepted and is basically pending, now you can show that receipt saying that, hey, look, I have some kind of temporary whatever pending petition, pending application with USCIS or with whoever. Whenever it comes to employment authorization document, however, it really depends on your eligibility. Meaning that if you do have a work visa, right? If employer, let's say employer is sponsoring your work visa, whether it's non-immigrant visa or immigrant visa, and you're here and you already have that visa, and this visa gives you the eligibility to work in the United States of America, based on this eligibility, you apply for I-765 employment authorization document. In this case, all right, because there will be more process. 765, you get the EAD, and then you have to go to the Social Security Administration and get the Social Security number, because all of that stuff is necessary for you to be legally employed basically in the United States of America. However, if you do meet this eligibility right now, right, and you already have the work visa and you already have the employment contract with your employer, it's at the discretion of the employer, they can say, you know what, we will take this receipt, your application for 765, we will keep it on file. Once you get the employment authorization document, apply, obviously send us a copy so that we can have it on file as well. Once you get it, apply for Social Security as soon as possible. Again, you will get the receipt from the, it's not necessarily called a receipt, or maybe it is, from the Social Security Administration. Basically just a letter saying that you have applied for a Social Security card, initial application. They will give you this letter, you will give this to the employer and say, hey, all right, now my Social Security is pending. Once I get that, I'll submit it. So at the end of the day, it really is at the discretion of the employer. And the reason for that is because it is for them that they have to fill out all the necessary, information to have you employed so that they can file taxes when it's time, right? So they need, obviously, the proof of your eligibility to work in the United States, and of course the Social Security number, so they can properly do all the tax stuff that they have to do. But with that being said, it is at their discretion whether or not they're okay with taking the receipt and saying, hey, you can continue working and everything. Once you get your employment authorization document, just make sure give it to us and we'll keep a copy. And once you get the Social Security number, we'll get that as well and update the record. Okay, so I hope I was able to answer your question. We're gonna move on to the next one from Vivian Jean Baptiste. Hi, I have my cousin who's waiting for her daughter. What can she do, please? Okay, so that was commented on the visa bulletin. So I'm assuming your cousin, she has a petition, I-130 alien relative petition for her daughter. So there are two things, and it really goes for everyone who has the I-130 petition going. On one side, you're actively working with your immigration case going that I-130 petition, right? What can you do actively working? You stay on top of all the dates. You consistently check, regularly, okay, that's the right word. You regularly check the visa bulletin. You make sure that you stay on top of the dates. You see how the backlog is, whether it's moving, whether it's not moving. If it's with USCIS, still, if it's not an NVC, then obviously you check the processing times with the USCIS and make sure that your case is not going beyond the processing times. If it is going beyond the processing times, again, you actively work on this immigration case. You submit the case inquiry. If it's with NVC, you submit the public inquiry. If nothing is happening, you take it a little bit further and then you submit complaints. You work with immigration attorney if something is becoming outrageous, right? So you are involved. You are staying on top of the immigration petition, not just you file and then forget. I mean, patience is important and it's good and it's definitely necessary whenever it comes to I-130 petitions. But at the same time, you have to verify that your patience is not just recklessness where you leave it up to whoever, wherever, to decide what's going on with your petition, but you always consistently check. So that's number one. That is the being proactive on the immigration petition. Number two options, not the option, number two thing that you have to do, right? Or you can do, basically the number two would be an option. I would say number one is not an option. You have to do that. Unfortunately, a lot of people don't do it, but you should be in control of, as much as possible, in control of your case. And then number two is, meanwhile, to address that separation that you have with your relative, you can work on some kind of non-immigrant solution. And in most cases, it's as simple as a regular B1, B2 non-immigrant visa, basically a visitor for pleasure. All right, that would be the B2, tourist visa. That's what it is. So you send a regular, your cousin can send a regular invitation to her daughter and say, hey, I'm inviting. Just make a letter, her name, her daughter's name. that she's inviting her daughter, that she hasn't seen her daughter for a very long time, and then addressing it to the U.S. consul in the U.S. embassy, saying, "Hey, please, can you give visitor visa to my daughter to come visit me because I haven't seen her for a long time." And then your daughter, not your daughter, your cousin's daughter, she goes to the embassy for the non-immigrant visa interview and hopefully gets a visa. Again, it's not a guarantee that she will get a visa, and depending on which country you are applying from, like for example, the country where I'm from, it's really, really hard to get a visitor visa, non-immigrant visitor visa. But depending, some of the countries, like for example, a lot of countries in Europe, they don't even need to apply for a visa, because if you have, I think if you are a citizen or a national of European Union, I'm pretty sure, I think you can come here to the United States. There is some kind of agreement between the United States and the European Union where US citizens can go to Europe for like 90 days without visa, and then the same goes for the nationals, not US citizens, but citizens of European Union. You get the point. But for some countries it's easier to get the visitor visa, for some countries it's harder. But basically, two options. You work, and I would say it's not an option. It's whether you choose to do it or not choose to. I guess it is option. But on one side, you're working actively with your I-130 petition, and on another side is you're trying to address that family separation that there is. And the best way in the meantime, while you have your I-130 petition, is through a non-immigrant visitor visa. Alrighty, I'm gonna do this, and we're gonna move on to the next question. Comment from MK: Can a C-26 renewal of H-4 employment authorization document file online, sir? Alright, let's take a look. Interesting question. We're gonna go to 765. We're gonna go to all forms. 765 employment authorization document, and that is available to file online. Honestly, I think you should be able to file online. I don't see the reason why you wouldn't be. Let's see if there's anything specific. Electronically? Nope. This is not it. Nope. Okay, so looks like so far you can. I don't see why you wouldn't be able to. Let's see in the instructions. C-26. Let's see. We're gonna find C-26 in here. C-26 is not even listed here. Okay, H-4 is not listed here. Well, it's not listed on the instructions at all. Let's see. C-26. Nope. You know what I'm thinking? It might be like that. C. And then 26. There we go. Aha! Found it. So very important to use the brackets, apparently. Spouse of an H-1B non-immigrant, which makes it H-4. File form I-765 along with documentation of your current H-4 admission or extension of stay. You must also submit documentation establishing either your spouse is a beneficiary of an approved form I-140, immigrant petition for alien worker, or your spouse received H-1B status based on the American competitive, and if that's applicable for you. For your convenience, you may file Form I-765 with Form I-539. However, we will not process your Form I-765, except filing fees, of course, until after we have adjudicated your Form I-539. You may also file Form I-765 at the same time as your Form I-539 and your H-1B spouse's Form I-129 petition for a non-immigrant worker. Please see USCIS. Okay, so yes, it looks like you can definitely file this form online. There is no exception, exemption, or anything like this. No, not exemption, exception for specifically for C-26 category. So yes, you can definitely file the form online. All of the documents that I'm mentioning here, you will see after you're done with the application online. You will have a separate right after the application. Once you're done with it, you will have a separate kind of a page where you upload. It will tell you which documents you need to upload, and you upload them in each separate field. Very straightforward. Just keep in mind, make sure not to forget about the Form I-539 and I-129 for your spouse. But I'm assuming if you're asking the question, then you are probably already staying on top of this situation. All right, let's move on to the next question. I think it's going to be the last one for today from Michael Maxwell. Good day, sir. I'm from Jamaica. My mom started filing for me in 2014. My filing improved. My mom passed away in 2018. I'm sorry to hear that. In 2018, my brother, who is a US citizen, is the substitute petition for me. Okay, he sent in all his documents, and I also sent in mine. Just one document did left for me to send in was my police record. I tried to send it in because of the pandemic. They put a stop. It did not went through. I got an email from USCIS saying they are reviewing my case from April 2021. Each time I check my status, it's saying the same thing. Can you tell me what's going on, or what can I do? Please help me. Await your reply. God bless. Michael, thank you for your question, for your comment. I really appreciate it. So I am assuming you are in F1 category. You got to be either F1 or F3, I'm thinking, because it's taking a very long time. And if you were under 21, it wouldn't be taking this long. So let me know if you can in a separate comment whether you're F1 or F3, but I'm going to take a look at the priority dates here because there is quite a significant difference between F1 and F3. There's about 7 years difference between the two categories. So if you are in F3, looks like the immigrant visas are becoming available right now for those who filed back in November 2009, which makes it a 14-year backlog. And that's as of right now, as of April 2023. And if you are F1, which is, well, the difference is F1 is unmarried sons and daughters of US citizens over 21. And F3 is married sons and daughters of US citizens over 21, obviously. Then it's August 2016, and that is about, well, between your case when it was filed 2014, it's 2 years, so you are 2 years over. But the thing is, whenever it comes to substituting the petitioner, it does create a little bit of a delay. So I wouldn't be surprised that it added, about 1.5 2 years to your wait already. One thing, however, I am kind of trying to see, and I'm gonna go actually to USCIS, because it sounds like from your comment, it sounds like your case is still with USCIS. It hasn't been transferred to the NBC yet, which does kind of it does sound a little bit like it's a little bit too long. So I'm gonna take a look at the USCIS processing times, and actually let me show you from the very beginning, because I want you to do that yourself, because I don't know all the information that I need to look it up properly. So if you can do that and let me know in a separate comment below, that would be very helpful. So this is the official government website, uscis.gov. You're probably familiar with it. We're gonna go to tools. We're gonna go to case status online. Now you already done the case status, you already checked, and you said it's the same thing. Probably says, oh, your case is being actively reviewed or something generic like this. But we're gonna scroll down to here, USCIS processing times information. We're gonna click on that, visit page, and here you'll select I-130 petition. You'll select the category, and for you it's going to be either US citizen filing for unmarried sons and daughters 21 or older, or US citizen filing for a married son or daughter, either this one or this one. But I'm going to select this one for now, and then you will select the service center where your petition is being processed. I'm going to select California for now, and we will get, see, 76 months. 76 months divided by 12, 6 years. So 6 years, you have filed in 2014, and then in 2018 there was a substitution. So assuming that added a little bit time, you're still quite over. So I'm thinking you're either in F3 or something is taking a little bit too long with USCIS. If it is taking too long with USCIS, when you check the processing times, and if you see if the time here is significantly longer than what you've been waiting for, all right? I mean, if you've been waiting significantly longer than this time listed here, all right, I got it mixed up. Scroll down and you will see inquire about the case outside normal processing times. If you click on that, it will give you an online form where you fill out all the case information and you submit this. This is basically the request for USCIS to take a look into your case. Now, it's not necessarily going to do anything. Most likely they will respond with a very generic response like, hey, we're still processing your case, everything is good. But once you get the response from them, then you can act further and either call, schedule an appointment to go and actually get the information in person, or you can call the customer service line and get the information in person. And if it's still the same thing, you can actually do more and file potentially, inquiry requests with local elected officials. Well, not you specifically, but your brother. Your brother, on behalf of you, can file, and him, you and him, the petition in general, file with local elected official, whatever. So maybe even not local, maybe even like state senators. He can file, an inquiry and say, hey guys, can you please take a look? I had the immigration petition way outside the normal processing times, if it is outside the normal processing times. So if you can, please check this yourself, or if you want, you can respond not within your own comment, but submit a separate comment with additional information that I need to check the processing times for you, and I will be happy to do that. So thank you everyone for watching, for tuning in, for asking questions. I hope my answers are helpful. However many questions you have, do not hesitate to ask them. There is no dumb questions. There is no too much questions on this channel whatsoever at all. All the questions are welcome. So thank you very much for watching. Thank you very much for your time. God bless, and I'll see you in the next video.